Your Honour, if it pleases the Court, my name is Macom, initials PJ, appearing on behalf of the defendant. The defence will submit an application for the exclusion of evidence as brought by the prosecution under Sections 130 of the Evidence Act and 590AA of the Criminal Code. The defence submits their application for inadmissibility on the basis that the information provided by my client was obtained from police officers who did not consider the requirements and obligations set out under the Police Powers and Responsibilities Act and corresponding regulations. The defence will make 3 key submissions to the court in response to the 85 charges laid against my client. However, it is important that I preface these submissions by stating that Mr. Ike is a juvenile and of Torres Strait Island heritage, which could be reasonably suspected from his appearance. I also note that the prosecution's submissions rest solely on my client's admissions as recorded by the arresting police officers. After taking Mr. Ike into custody, the arresting officers drove my client around the neighbourhood and proceeded to point out various properties that had been burgled. Due to my client being of minority age, the arresting officers at this point were obliged to inform my client of his right to contact a friend, relative, or lawyer or legal guardian of Mr. Ike to accompany him to the police station. There was no documented effort made by either officer to this effect. During the trip, my client was questioned by one of the officers in relation to the burgled houses. I note that Mr. Ike, during this trip, stated that he had committed these burglaries. However, the defence submits to the court that my client's statements were made as a result of gratuitous concurrence. Gratuitous concurrence is the tendency for a person to agree with every proposition put to them, regardless of whether it is the truth or not. For many Indigenous people, using gratuitous concurrence during a conversation is a cultural phenomenon and is used to build or define the relationship between the people who are speaking. It has been documented in the transcript that it was clear my client, through body language, was not consciously engaged in the conversation with the arresting officer. Examples of this include a lack of eye contact and short responses that stretch little beyond the term yes. I refer your Honour to paragraph 13 of the transcript in which it states that my client agreed to the proposition of burgling a particular house without even looking at that house. Here, the officers also disregarded their obligation to advise my client of his right to speak with a friend, relative, or lawyer before questioning under Section 418 of the PPRA. My client is vulnerable and exhibited little understanding of the events that were occurring. Further to the above, Section 421 of the Act outlines the special procedures that must be undertaken by questioning officers when dealing with children. Although my client was provided with the opportunity to speak with a support person in private, Mr. Ike was not given the choice of his support person. The support person that was provided offered little direction on what was happening and how to conduct himself. The only advice that was provided was to answer the questions. I further refer your Honour to Clause 25 under Schedule 9 of the Police Powers and Responsibilities Code, which provides a standard of questioning that police powers must adhere to when interviewing Aboriginal and Torres Strait Islander adults. Prior to questioning, police officers must first ask questions necessary to establish the person's level of education and understanding. This is the standard that must be applied to adults. I would therefore like to emphasise the importance of its application to juveniles. Although the arresting officers asked my client questions before laying charges, those questions were not capable of establishing if Mr. Ike could effectively communicate or whether he had an understanding of what was happening. Therefore, despite the provisions laid out under Clause 25 of the Responsibilities Code, at no time did any officer appropriately attempt to ascertain whether my client could comprehend the nature of the events and continued to operate without considering that a Torres Strait Islander child would have a further level of disadvantage in comparison to an adult. In light of all of this information, it is likely that if the involved officers had abided by the relevant stipulations laid out under the PPRA and its corresponding regulations, my client would have been able to access an appropriate support person of his choosing, which could have assisted his understanding of the events and therefore encouraged my client to provide accurate information. Finally, the defence submits that the actions of the police officers involved with my client's arrest are inconsistent with the rationale and governance of the police powers as set out under Section 5E of the PPRA. The Act provides that police are vested with power to ensure public fairness to and protect the rights of persons against whom police officers exercise powers under the Act. There is no valid reason, in consideration of the circumstances of my client's arrest, why competently trained and professional police officers could not adhere to the obligations and standards of the PPRA. As per Justice Aiken in Bunnings and Cross, it is society's right that those who enforce a law must also respect it. For the reasons I have set out before the court today, I submit that the evidence relied on by the Crown should be deemed inadmissible and my client's charges dismissed. To omit such evidence would be a flagrant disregard for the current law and its purpose. Thank you.